Stand by.
This is Based in Fact, a true crime podcast. Join host Lisa O'Brien as she examines America's most infamous true crime cases through the lens of the court, not the court of public opinion. No spin, no theories, no rumors, just facts. Here's Lisa O'Brien.
In episode 19, Kyle and I are looking at State of Texas versus Henry Watkins Skinner. In 1995, Skinner was convicted of capital murder and sentenced to death for the December 31st, 1993 murders of his girlfriend, Twila Busby, and her sons, Randy Busby and Elwin Caler, in Pampa, Gray County, Texas. Skinner has admitted that he was in the house when the murders occurred, and he was the only member of the household to walk away that New Year's morning. Early DNA testing linked Twila and Elwin to Skinner's blood-soaked clothing that Skinner was wearing when he was arrested. In 2001, he began pursuing DNA testing in the Texas courts. After his second request was denied in 2019, he sought relief under 28 U.S.C. 1983 in federal court, pursuing his claim all the way to the U.S. Supreme Court. In part one, we'll talk about the evidence against Skinner, his direct appeal and post-conviction claims in state and federal court. And finally, we'll talk about the impact of Skinner versus Switzer on Skinner's case and his pursuit of DNA testing in state court. And good afternoon, Kyle.
Good afternoon. How are you today?
Very well. Just getting through to the end of the year.
Yeah, it's that crazy time of year where the year starts to wind down and everybody's focused on the holidays. It's not good times.
Yes. So, all right, let's get started because we've got a lot to do today. This is, of course, Henry Watkins, Hank Skinner. This is part one. There's a lot of material. The murder goes back to 1993, so I'm going to cut it into two parts. Let's start, as usual, as always, with the victims in this case. The first is Twila Jean Ward Busby. She was born February 15th, 1953, although some sources put her birth date in 1952. Her parents are Bobby Jean Ward Sr., who was born in 1934 and died in 2005, and Beverly Ann Donald Ward Clark, who was also born in 1934 and died in 2007. And interestingly enough, we have an Oklahoma connection tonight because Beverly is from Oklahoma. And I believe Bobby Jean Ward was also from Oklahoma. I don't know where Twila was born. She may have been born in Oklahoma and moved to Pampa later in life, or she may have been born in Pampa because her family moved there prior to her birth. It's a little unclear.
Right, got it.
And then also, Twila had a stepfather named Melvin Leon Clark, who was born in 1921 and married her mother in 1972, I believe. Twila had three siblings: Douglas Ray Ward, who was born in 1955 and died in 2007; LaDonna K. Ward Alderson, who was born in 1956 and died in 2003; and then Bobby Jean Rusty Ward Jr. I don't know his birth date, and he's still alive as far as I can tell.
Yeah,
Then,
her poor parents lost, I mean, I don't know what year in 2007, but 3 kids.
I think Douglas had health problems, and I think he died shortly after his mother died.
After his mom, got it.
Yeah. And Bobby Jean Ward died when he was visiting family in Pampa. So, and then I want to go through the maternal relatives also of Twila's. She has Orpha J. Donnell, her grandmother, Orville M. Donnell, who was an uncle, but he did die in 1991. Lewis Frederick Donnell, nicknamed Bub, he was born in 1927. He was an uncle. And then Robert Eugene Bob Donnell, he was born 1930. He did die in 1997. He was another uncle, and he will come into play later. She was married at one time to Melvin Randolph Busby Sr. I don't have any information about him. She had 3 children, Elwin F. Scooter Caler, who was born in 1971. He's also been called Elwin Busby, but most of the records have his last name as Caler. Melvin Randolph Randy Busby Jr., who was born in 1973. And then Lisa Joanne Busby, who was her daughter, and I don't know her age, and she is, I know, still alive. Twila's injuries, cause of death, were strangulation and blunt force trauma to the head. The second victim in this case is Elwin F. Scooter Caler. He was born May 20th, 1971. It's not clear whether he was born in Oklahoma or in Pampa, Texas. I'm not sure who his father was. His mother was Twila. He had Randy and Lisa as his siblings. He was disabled, secondary to muscular dystrophy, diabetes, and he had intellectual disabilities. His injuries and cause of death were stab wound under the left arm, which punctured his lung, and superficial wounds on his right hand and stomach. And then the third victim is Melvin Randolph Randy Busby Jr. He was born January 31st, 1973. His parents were Melvin Randolph Busby Sr. and Twila. He had Elwin, Scooter, and Lisa as his siblings. He also had intellectual disabilities, and he may have had some physical disabilities, but it's not clear. And he was stabbed multiple times in the back. And Elwin actually died on January 1st. Twila and Randy died on December 31st.
Got it. And but Scooter is probably, we think, a half brother, right? Different last name, probably just a half brother of the other two.
He's likely a half brother of Randy and Lisa, but he had lived with, his mother, and he was the oldest child. So, and he was living with his mother at the time of his death, although he wasn't listed on the lease. So he may have recently moved back in with his mother prior to being murdered by Hank Skinner. Our perpetrator is Henry Watkins Hank Skinner. He was born April 4th, 1962 in Danville, Virginia. He had been married at one time to a woman named Connie Neighbors, and they divorced. I have found some resources that say he had a son and 2 daughters. I'm not going to name them because they don't deserve to be associated with this, although the daughters, I believe, are in his life, and that's their prerogative. He lists his occupation as paralegal, which says to me that he thinks he's smarter than everybody else. And he does use that as filing pro se legal pleadings and threatening people with litigation and things like that.
Now, was he a paralegal at the time, or is that something he's done since incarceration?
Well, it's funny. I can't find any type of work history for him. He claimed that he was trained as a paralegal and that he was working for an attorney in Pampa at the time. But again, I can't find any documentation or proof that he actually did work for anybody at the time. And, you know, if you're spending a day drinking all day on New Year's Eve, you're probably not working.
Right.
You're probably not gainfully employed. I'll
No,
say.
exactly. Well, and without chasing a rabbit, but is there any kind of, yeah, I mean, I know you have expertise in this. Is there some sort, I mean, I'm assuming being a paralegal, there might be a little bit of a background check or, you know, maybe not admitted to the bar, but is there some sort of organization a little bit higher that, you know, a little bit more scrutiny than just an average person off the street? I'm thinking
Well,
about some of his, you know, previous, you know, problems with
there
the law.
there are no well, I take that back. There are now ABA accredited certification programs. And you can take a some schools are now even offering a bachelor's degree course in paralegal studies. But you can also become a paralegal through experience. My mother was a paralegal through 20 plus years of experience as a legal secretary, legal assistant. I did get a paralegal certificate in 1991, but I also, through experience, have honed my paralegal skills. So it's not like you don't have to go to law school, and you don't even necessarily have to necessarily graduate high school, but you also can call yourself a paralegal when you're not.
Right.
So
makes sense.
And it's not as it's not as wrong as calling yourself a lawyer when you're not.
Right.
Because that is there you have to take state bars and, you know, things of that nature. Although the, Juris Doctorate degree is actually what makes you a lawyer. But in order to practice, you have to take state bars and be licensed to practice. And I think
I feel like this is one of those things, the difference between being a lawyer and an attorney.
Yeah. So, well, they're synonymous more or less. But to practice, the JD makes you a lawyer. But to practice, you have to be licensed.
Right.
And if you're not licensed, that gets you in a lot of trouble. Emotional, mental for Skinner, and most of this is just my impressions based on observing him in his interviews and reading different things about his criminal background and his social background, social history. He is a sociopath. He is a manipulative person, and he does have a long history of alcohol and drug abuse. He may deny all that, but that is what the picture that gets painted of him through multiple sources over multiple years. He has a long criminal history involving arrests, but most of his offenses are unadjudicated. He does have 2 convictions, one for aggravated assault on a police officer in January 1988, which he received probation for. Then he had unauthorized use of a motor vehicle, which was in March of 1988. His probation was revoked and he served 5 years in prison. He had an aggravated assault with a deadly weapon charge in December of 1988. He also had 2 drunk driving arrests in 1993, one in August and one on an unspecified date. He was accused of statutory rape in 1981. He's been accused of breaking and entering. He's been accused of drunk in public. And this is where the calling himself a paralegal has come in, because when he is arrested, he makes as much trouble as he can in the jail, and he threatens the jails with lawsuits that generally never come to pass. He also is manipulative in that you can see him break a window and he will tell you, I didn't do that. Or he'll tell you, oh, I didn't mean to do that. I was stretching. and I accidentally hit the window and it broke.
That's so
And probably extrapolating a little bit, he would probably hit a woman and tell her it's her fault. You know, like punch her in the
Yeah.
face and say, that's your fault. You shouldn't have made me mad.
Or her face got in the way of his fist.
Correct. He was stretching and her face got in the way of his fist. Yeah. So that's the kind of person we're dealing with. And so of all the criminal defendants, and I said this about him in Clear and Convincing, and I say it now because I still believe it, I would not believe Hank Skinner if his tongue came notarized. And with Hank Skinner, I want documentation and
Right.
3 independent sources of everything he claims, because he is so manipulative and he's so slick and he's such a quick talker. And, you know, with him, the story is always evolving. So the story he told in 1995 about what happened on the night of December 31st is totally different from the story he told in 2010, because he's trying to make what he knows fit about the evidence. He wants his facts to fit that evidence. Even though most of it is stuff he's made up anyway. And again, the victims were Twila Jean Ward Busby, Melvin Randolph Randy Busby Jr., and Elwin F. Scooter Caler. And so that is our perpetrator. Him saying I'm innocent, I didn't do this, is worthless. Absolutely worthless. And spoiler alert. So, all right. So let's go into the facts of the case. Again, the victims, Twila, Randy, and Scooter. The crime occurred at 804 East Campbell Avenue in Pampa, Texas, 79065. That is in Gray County, Texas. And I believe that is in the Panhandle.
Yeah, that is right. Yeah, Pampa is in the Panhandle of Texas, and it's probably 45 minutes from Amarillo, which sits kind of like right in the middle of the Panhandle. So I think it's a little bit maybe northeast heading, you know, that's why there's the big Oklahoma connection. I think it's pretty close to Oklahoma, both to the north and to the west of Oklahoma. Correct. Or Pampa is the south and west of Oklahoma. Yeah.
So Skinner and Twila met during the summer of 1993, although it's kind of unclear because there's some information that he and his wife Connie Neighbors were splitting up in September. So it may have been a little bit late summer, maybe early fall of 1993. After Skinner was released from prison, where he had been serving time for unauthorized use of a motor vehicle. He moved in the house that Twila shared with her disabled sons, Elwin and Randy, and her daughter, Lisa. Twila and Skinner did share drug and alcohol problems, making their relationship a volatile one. And as is usually the case with a lot of alcohol and drug use, Skinner became unpredictable when he was drinking and using. And there are different stories about Twila as to the extent of her drug use. But she definitely had an alcohol problem, because she was described as liking her drink.
Yeah, and I mean, is there some thought that maybe, I mean, I don't want to blaspheme the dead, but has there ever been any thought that maybe her children's disabilities might have been fetal alcohol? Because it's, I mean, to have 2 disabled children I think is relatively unusual. I mean, is there any thought that maybe?
I don't know. And I don't know. Twila, I believe, also had some disabilities.
Got it.
Physical and mental, emotional.
Well, that makes more sense if it's,
I believe. And there may be, it may be that her family was I'm going to use odd. And her mother's family was odd and her father's family was odd. I don't know. But I'll get into that a little bit more because of the relationship between Twila and some of the allegations about the relationship between Twila and her Uncle Bob, but we'll get into that a little bit later. All right. On New Year's Eve day, 1993, Skinner and Twila spent the day partying and drinking and taking drugs. At 9 p.m., Skinner called Howard Mitchell and asked for a ride to a New Year's Eve party being hosted by Mitchell's daughter, Sarah. When Mitchell arrived around 10 o'clock to pick Skinner and Twila up, he found Skinner passed out on the couch and couldn't rouse him. Twila left for the party with Mitchell and took Skinner's bottle of vodka with her. She did express concern that Skinner would be angry if he woke up while she was gone, but she went to the party anyway. Once she was at the party, her uncle, Robert Bob Donnell, allegedly followed her around making inappropriate sexual advances. Mitchell, however, described Twila's reaction to Bob as being more aggravated than fearful. When she'd had enough of Donnell's behavior and perhaps out of concern that Skinner would wake while she was gone, Twila asked Mitchell to bring her home. He stayed in the car when they reached the house on East Campbell Avenue between 11 and 11:15 on the night of December 31st. The last time Twila was seen alive was when Mitchell watched her enter the house she shared with Skinner, Elwin, Randy, and Lisa. Lisa had asked to stay with her grandmother that night because she was concerned about Skinner's heavy drinking. So, but for Lisa deciding to stay with Beverly Donnell, she might have been among the victims in this case. She very likely would have been, unless she was able to get out of the house before Skinner got to her. At midnight, Officer Fred Courtney of the Pampa Police Department was dispatched to investigate a stabbing. He found Elwin on a neighbor's porch, bleeding profusely from a stab wound under his left arm. Elwin died at the hospital at 12:45 a.m. on January 1st, 1994. Pampa police officers followed a blood trail back to Twila's house, where they found Twila's body on the living room floor next to a bloody axe handle. An autopsy would later reveal that she'd been strangled and beaten to death. Randy was found dead in the top bunk in the boys' bedroom. He had been stabbed 3 times in the back. Officers did not find Skinner in the house passed out on the couch. And this will be crucial later on. After killing Twila and Randy and mortally wounding Elwin, Skinner, in bloody pants and shirt, made his way out the back door of the house and to the trailer of an old girlfriend, Andrea Reed. When Andrea's daughter opened the door, Skinner barged into the trailer, claiming he had been stabbed and shot. Reed was unable to find any wounds except for a deep cut to Skinner's right hand. While at Reed's trailer, Skinner removed his shirt, burned needles to sterilize them, and bent them to use to stitch up his hand. He asked Reed to stitch the wound when he realized that he couldn't. When Skinner caught Reed trying to call police, he threatened to kill her and her children. Over the course of 3 hours, Skinner made conflicting statements about what had happened. In response to Reed expressing a desire to call Twila, Skinner told her he caught Twila in bed with her ex-husband and beaten the man before throwing him out of the house. After swearing Reed to secrecy, Skinner told her that he may have kicked Twila to death. At around 3 a.m., police tracked Skinner down to Reed's trailer. When they entered the trailer, they found Skinner hiding behind clothes in Reed's closet. Skinner had an outstanding warrant for injury to a child and aggravated assault, and when he was told he was being arrested on those warrants, he said, "Is that all?"
It's always the changing story that seems like, a key to guilt. I mean, not saying that things don't get fuzzy. You may misremember things, but when there's dramatic changes to your story, that's a pretty clear sign that you've done something wrong.
Correct. In a videotaped interview later that morning, Skinner claimed to police that he and Twila fought after he caught her in bed with another man. He told police the man was Shane Bromlow, not her ex-husband. He also claimed that they argued about her leaving the house that night and admitted that their fight turned violent and that he struck Twila with the axe handle. He also claimed that Twila attacked him with the axe handle and with a knife, and that he killed her defending himself. Alternatively, Skinner, while admitting that the fight occurred in the living room where Twila's body was found, denied any memory of details. Finally, he tried to blame Elwin and Randy's death on Twila and insisted that he acted in self-defense when he killed her. So even in that short period of time, the story is evolving and changing, probably as he's finding things out about the crime scene, about the wounds, about the injuries. And, it's not because he's innocent. It's because he's trying to make his story fit what police are finding.
Yeah, exactly.
He was arrested on January 1st, 1994 by the Gray County Sheriff and the Pampa Police Department. He was ultimately indicted on January 31st, 1994, which would have been Randy's 21st birthday, of capital murder. And that is killing more than one person in the same transaction or the same event. The venue for the case was the 31st District Court in Gray County, Texas. Skinner was represented by Harold L. Comer, who was a former district attorney, another man by the name of Kenneth W. Fields, and initially for a period of time by an attorney named Rick J. Harris. Of course, the state and Gray County were being represented by the district attorney, John Mann. On February 24th, the counsel were appointed for Skinner, and Skinner was given an order granting his request for investigative assistance. On April 25th, 1994, Skinner was granted an order that enjoined the Gray County Sheriff Office from reading, opening, or copying Skinner's mail, which he was accusing the sheriff of reading and copying his privileged mail or attorney-client mail and then providing it to the DA's office, although he's never proven that that's actually what happened. He's just alleged that it's happened. At trial, counsel, and I forgot to say, venue was moved on September 13, 1994. Venue was moved out of Gray County into Tarrant County in Fort Worth. Tarrant County, Texas, and Fort Worth. And that was probably due to the small fact that, Gray County is probably a small county with a small town, and finding a fair and impartial jury would have been difficult.
Yeah, absolutely.
At trial, the state was represented by John Mann and Tracy Jennings. And of course, Skinner was still being represented by Harold Comer and Kenneth W. Fields. Jury selection began on January 19th and concluded on March 7th, 1995. Although it looks like it wasn't every day. It looks like jury selection went, a few days the first week, a few days the second week. It wasn't continuous from January 19th to March 7th. And we've seen that in other cases like Rodney Reed. And then the guilt innocence phase one of his trial, began on March 7th and ended on March 15th. The jury appears, from what I can find, to have deliberated for 3 days before finding Skinner guilty. And even though we're going to talk more about the evidence or the DNA evidence next show or part 2, it is important to note that even his conviction, there is DNA evidence. The state collected various items from the scene, including samples of blood found on Skinner's shirt and blue jeans, which were submitted for DNA testing. The results revealed DNA profiles consistent with Twila's, Elwin's, and Skinner's in that blood on his clothing. A forensic analyst testified that only 1 in 5.5 billion people would have the same DNA profiles as the one extracted from these blood samples. And basically what that says is that Skinner, Twila, and Elwin were all bleeding, and blood got on Skinner's clothing. Fingerprint evidence also showed that bloody handprints found on the door frame and doorstop molding in Randy and Elwin's room, where Randy's body was found, were consistent with Skinner's prints, and bloody fingerprints were also found on the knobs of the door leading from the kitchen to the utility room, and a handprint on the knob of the door between the utility room and the backyard was also identified as Skinner's. So again, we've got bloody handprints on doorknobs leading out of the house. So that was the early DNA testing. That underlines, plus we've got the fact that Skinner is in the house when these murders occur. Skinner had never said prior to his trial that someone else came in the house. He never said he saw anyone else in the house. He basically denied any knowledge, and his defense at trial was that he was so stuporous from ingesting alcohol and codeine that he was incapable of committing the murders. He was incapable of beating Twila. He was incapable of stabbing Randy and Elwin. He also claimed he had an injury to his hand that left him incapable of doing these things. And his defense was able to present expert witnesses to support those defenses, but the jury ultimately did not find the defenses sufficient to create reasonable doubt, and so they convicted him. The penalty phase was held between March 20th, 1995 and March 23rd, 1995. And on March 23rd, the jury sentenced Skinner to death. And a death warrant was actually signed that day as well by the judge, but that's just a pro forma date that is probably put in place to ensure that direct appeal occurs in a timely manner. And formal sentencing appears to have been on April 20th, 1995. Because there's usually a delay between the jury's sentencing and the judge actually pronouncing on the record in open court. On direct appeal, Skinner was represented by an attorney by the name of Stephen C. Loesch, and the state was represented by John Mann and Matthew Paul of the AG's office. Skinner's notice of appeal was filed on July 11th, 1995. The points of error that he raised in the direct appeal are, again, totally different from what he's claiming now. Just going to say. First of all, he claimed the evidence is legally insufficient to support the verdict that he killed 3 people during the same criminal transaction, that a document prepared by an expert testifying on behalf of Skinner constituted privileged work product. Basically, during the cross-examination of that expert, he was ordered by the court to turn over a document that he had prepared with questions to get information from Skinner's attorneys. And the judge thought that because he was testifying, that made that document discoverable. So that's one of the issues raised.
Is that right, or does that?
Well, it's not necessarily. There are certain rules that when you have an expert testifying, this applies in civil and criminal.
Right.
He has to provide opposing parties or the plaintiff's attorney or the attorney presenting that expert has to provide what the materials that the expert reviewed in reaching his opinions. And that is to be usually used to cross-examine that expert about those opinions. For example, if you have say in a personal injury case, you have a doctor relating a back surgery to this accident, and then it turns out that the patient was in an accident 3 years before, and had gotten a surgery recommendation as a result of that accident, but didn't follow through and have the surgery. That leads somewhat to that the back surgery wasn't necessarily related to the accident at issue in that particular
Got
case.
it.
It's related to the prior one.
Right.
So it's used to cross-examine, and it's used to evaluate whether or not that expert's opinion is 100% legitimate, or maybe a little fudging of the facts.
Right. Yeah. Or even maybe potentially to impeach the expert, maybe.
It can be to impeach the expert, correct? Because a lot of times, I've seen it happen where a treating doctor is asked, well, what about these records? And the treating doctor says, well, that doesn't change my opinion. Well, then, that treating doctor's credibility goes down a notch, because it should change your opinion. Maybe not 180 degrees, but it should change your opinion a little bit, that maybe the combined effects of the first accident and the second accident resulted in being unable to put off the surgery any longer. So just to go into a civil realm that I'm more familiar with. And for example, we have a deposition coming up for an expert witness in a personal injury case, and we did not get the materials that he relied on. We did not get his report except as part of a motion filed on behalf of the plaintiff. So prior to the deposition, we should have gotten, an official report as well as the documents he relied on, and we didn't get those things. And so we're going into this deposition without those things. Whether we're going to go through with the deposition or whether it's going to be held up, and I've seen them held up, because I've seen them come in and say, we asked you to produce these things, you didn't do it, now we're formally asking you to do it on the record, and if you don't, we're going to move to strike you. Or asking the plaintiff's attorney to do it, or we're going to move to strike your expert. So, and we have to do the same thing for our experts. We'll have to send everything that our experts relied on prior to them being deposed. Then there are several he raised multiple points of error that revolve around the same admission of the same thing. He alleged that the disclosure violated rule of criminal evidence 614, that it violated attorney-client privilege, that it violated the work product doctrine, that it violated his due process rights. And then he also alleged that the trial judge erroneously precluded him from asking veneer members, that's potential jurors, whether they could consider evidence that was not related to his blameworthiness to be mitigating evidence. He also alleged, in effect, saying that he alleged the trial judge erred when he refused to instruct the jury on the lesser included offense of murder, claiming that he was entitled to the instruction because the jury could have found his voluntary intoxication temporarily destroyed his capacity to form the culpable mental state required to convict him of capital murder. He also alleged that the jury could have found that his voluntary intoxication negated the mens rea of intent or knowing action, thus making him guilty only of the lesser included offense of reckless murder because he caused the death of each victim by performing an act clearly dangerous to human life while in the course of committing the reckless or negligent homicide of the other victims. Now, to me, that doesn't sound like somebody saying I didn't do it.
Well, that's what I was thinking. I mean, when you were saying that, I was like, wait a minute, doesn't that mean he just said he did kill them, but it was more of like a legal.
But it was because he was so drunk and high
right.
that he didn't mean to kill him.
Yeah, because I was like, wait, that sounds like he just admitted he did it. He just didn't do it.
He was stretching, and Twila ran into the axe handle multiple times.
Yeah, exactly.
He was stretching, and Twila put his hands around her throat and strangled herself. He was stretching, and he accidentally, holding a knife, and he accidentally stabbed Elwin. He was stretching, and he accidentally stabbed Randy 3 times in the back, while Randy's asleep on the top bunk, and all indications are that Randy never knew what he did because Randy was asleep. Randy was found lying face down on the bunk, dead. He also challenged Texas Penal Code 8.04A, which says voluntary intoxication does not constitute a defense to the commission of a crime, and claimed that rule did not bar him from seeking or receiving a lesser included instruction for murder. The definition, he challenged the definition of intentionally in the abstract portion of the jury's instructions, claiming it was fundamentally erroneous because it authorized a conviction for capital murder without requiring the jury to find that element of the crime. In other words, the definition included in the charge described a culpable mental state not existing in Texas law. He claimed the trial judge erred in admitting irrelevant testimony at the punishment phase of trial, which basically was testimony from his ex-wife regarding some of Skinner's sexual proclivities that he forced her to participate in. And I'll leave it at that. He claimed that evidence was irrelevant to any issue in the case, and its prejudicial impact substantially outweighed any probative value it may have had. He claimed the trial judge erred in denying his request for a limiting instruction at the penalty phase that directed jurors to separately consider the evidence of each extraneous unadjudicated offense that the state alleged against him. He claimed that error violated Article 36.14 of the Texas Rules of Criminal Evidence, or Articles 36.14 and Texas Rules of Criminal Evidence 105A, that the error violated the due process clause of the 14th Amendment. He claimed the trial judge erred in refusing to instruct the jury that unadjudicated extraneous offenses must be proven beyond a reasonable doubt. He claimed the trial judge erred in refusing to instruct the jury that Skinner was presumed to be innocent of those extraneous offenses until the state proved them. The trial judge erroneously overruled an objection to the prosecutor's statement to a prospective juror that the state would scientifically prove that appellant murdered Twila Busby with an axe and stabbed 2 retarded kids with a knife. And finally, he claimed that his death sentence violated the 8th Amendment because Texas does not have a uniform, consistently applied standard governing its imposition. In other words, the number of different schemes in effect since 1989 created different standards of imposition, resulting in constitutional violation. The case was scheduled for oral argument, but then ultimately not argued. It was submitted to the Court of Criminal Appeals on October 23rd, 1996. They rendered their decision on May 21st, 1997. And basically they found that the court held that the documents that were produced did not contain facts or data underlying the expert's opinion, so they were not discoverable, and that they did reflect the expert's mental processes upon his initial review of the case. But they ultimately found that that was not a harmful error. It didn't affect the jury's verdict, and so they did not, they overruled that error and affirmed the conviction and sentence. Skinner filed a motion for a hearing on June 3rd, 1997, and that was denied on September 10th, 1997. He did file a writ to the U.S. Supreme Court, which was denied on April 20th, 1998. So his conviction and sentence became final on April 20th, 1998. Any questions, thoughts?
No, it's just a lot of information. I'm just trying to digest it. It's a lot of interesting details.
Yeah. But again, Skinner wasn't saying I'm innocent. I'm actually
Well,
innocent.
yeah, I mean, I think that's the thing I'm trying to process is this weird dynamic of where I mean, again, as I've said, it's where their stories just completely change. And so they say, oh, it was, the one-armed man, and then they continually change. But then also when they move to, oh no, I actually did cause their life to end, but legally it wasn't murder. It's like all these changing things. That's how you kind of know that they did it.
So, and also I want to point out that during the trial, they did get in evidence about what happened with Bobby Donnell, and they did have people testify that Twila's relationship with Bobby Donnell may have been, there may have been sexual contact between them, either consensually or not. But
falls under what's wrong with people.
And it's funny. It's like Donnell was accused of attempting to rape another woman, a friend of Twila's, I believe. But so was Skinner was accused of trying to rape another friend of Twila's. So, I mean, Bobby and it's funny, Donnell and Skinner are men cut from the same cloth. Skinner just doesn't want you to see that. He wants people to think he's a good guy.
Well, I mean, I don't know. I feel sorry for somebody like Twila and her children. I mean, you think about it, and we've all seen these places, these poor people, they just really don't have a chance. I mean, they are born so far behind the 8 ball in life that really through no fault of their own, whether it's, they're just, I don't know. I feel for her and all the stuff she had to deal with in her short life.
Yeah. Yeah. And I have to note, she was older than Skinner. She was about 10 years older. 9-10 years older. So he's apparently some kind of winner. I don't see it, but
yeah, I mean, that's the thing too. I mean, some of these guys, I'm amazed at how that's another thing that's kind of amazing to me as well, is how they're able to, I don't know, find women that are interested.
All right. So Skinner moved on to state post-conviction. Counsel was appointed, and that was Stephen C. Loesch, who was his direct appeal attorney, on July 25th, 1997. Now, under Texas law, for post-conviction, that made Skinner's application for post-conviction relief due on or before January 21st, 1998. And that's 180 days after an attorney is appointed. The rules are pretty forgiving. You can file an initial application, and then you can supplement it as you develop additional information. Lord knows, Rodney Reed's done it bunches of times. So you're not, and you can add claims, but you have to have that initial application filed within 180 days of appointment of counsel. The venue, the application has to be filed in the convicting court, but then it's transferred to the Court of Criminal Appeals to determine whether it should proceed, whether it should be whether you have an evidentiary hearing necessary, or whether it can be decided on the record. The application was filed at the 31st Judicial District Court on March 26, 1998, which is about 2 months late. Skinner, the attorney, did file a motion for extension of time in January of 98, but he filed it at the Court of Criminal Appeals. They dismissed it as not in the right court, because you're actually supposed to file it in the convicting court. but they dismissed it without prejudice for him to go file it in the convicting court. He didn't file the extension of time request in the convicting court until the day after his application was due. And then he still didn't file the application itself until a little bit more than 2 months later. The application was forwarded to the Court of Criminal Appeals on April 13th, 1998. The Court of Criminal Appeals on June 1st, 1998 did remand the matter to the trial court for a hearing to determine whether good cause existed for the late filings.
Does anything happen to attorneys when they just kind of make these basic clerical errors that you figure anybody that's, can pass the bar should know? Like, does anything happen to them?
Well, it is malpractice, and it can result in a referral to the state licensing board.
Right.
It can result, and I've seen one attorney in death penalty cases in Texas who has lost his or been suspended from practice before the Court of Criminal Appeals because of a habit of filing late.
Because this just seems like basic blocking and tackling that anybody that the first year law student should know.
Right. Well, it's sometimes, and I know this from experience, sometimes the rules and the calculation of time, it's like I'm speaking English and they're written in a form of ancient Greek. And they're kind of sometimes difficult to decipher, but that's where you talk to your peers and you say, this says this. This is what I think it means. What do you think?
Right.
And, really what should have been done, and we've done this, we filed requests in 2 courts just to ensure that we file the request in the right court. And when you're dealing with criminal cases, it's not as daunting as it can be in civil cases.
Hmm.
So when he filed the request in the criminal appeals, he should have also filed it in the trial court. And I'm going to say, if your application is due in the trial court, that's where you ask for more time.
Yeah, because he didn't ask for time first, right? He just made a mistake.
He asked for time in the Court of Criminal Appeals.
Filed it in the wrong place
first, which is technically the wrong place because the application isn't due to be filed to the Court of Criminal Appeals.
We gotcha.
And it can probably be a little confusing because there are some things that you do ask the Court of Criminal Appeals for directly that you can't ask the trial court for. But again, if your application is due in the trial court and you need more time to prepare your application, the trial court is the one you should be asking for the extension of time. Or if you, when in doubt, file one in the trial court and one in the Court of Criminal Appeals. And a big caveat in any court, in any state, in any practice, you don't file something the day after. You don't file a request for more time the day after something is due.
No, that seems to be worse.
As soon as you can before it's due, or no later than the day that it's due. And it's sometimes not a good practice to file the day something's due, because you never know if the court is going to be able to address it that day.
Right.
And what happened apparently is because they filed the day after the application was even due, the trial court, the district court, did not take any action on the extension of time. Nor did they seek any action by the trial court. It's like one of the things I criticized Eccles post-conviction attorneys for was filing a motion for DNA testing in 2002, but not setting it for hearing and not providing an order or seeking any action by the trial court as to the motion for 2 years. But I think they were filing it so that if anything started to proceed that they wanted to stop, they could use that previously filed motion as a jumping off point. So anyway, the case went back to the trial court in Gray County. The judge was the Honorable Kent Sims. He filed his findings of fact and conclusions of law, and the writ was supplemented on, or a supplemental record was filed on June 24th, 1998, pursuant to the Court of Criminal Appeals order. Their opinion was rendered on December 2nd, 1998, and they dismissed Skinner's first post-conviction writ as untimely. Judge Mansfield conferred with that decision. Judge Baird dissented, basically because he believed or felt that Judge Sims's finding of no good cause was an abuse of discretion. Basically, what the Court of Criminal Appeals held was that the motion for extension of time filed on January 19th at the Court of Criminal Appeals was denied on the 21st of January because without prejudice to seek extension in the trial court, because the Court of Criminal Appeals was not the correct venue. The trial court took no action on the motion filed on January 22nd, 1998, after the writ was due. The writ was due no later than January 21st, 1998, and Skinner failed to show good cause for the late filing under Article 11.071. Now, one of the things the attorney claimed, he had a busy trial practice, he had a busy criminal practice, and he just didn't have time to get the writ done. He didn't offer anything, for example, that, he was prevented from talking to Skinner to help prepare the writ, or he was prevented from accessing his law office, or the DA prevented him from obtaining materials. And really, he had been appointed to represent Skinner in his direct appeal. So he'd been representing Skinner since 1995. And he'd done the direct appeal. So he
Well, yeah,
knew
that's
what
what
the
I remember.
issues
He
were.
wasn't a new guy. It wasn't like he was a brand new attorney. He should have some basic understanding of the case.
So ultimately, the writ was dismissed as untimely on January 27th, 1999. Skinner filed a motion for consideration, which was also denied the same day. He went on to federal habeas, pursue federal habeas claims. He was represented by Douglas Robinson and Stephen C. Loesch. The state was represented by Catherine D. Hayes at the AG's office. The case was filed in the United States District Court, Northern District of Texas, Amarillo Division. He filed a petition for writ of habeas corpus on February 5th, 1999. The grounds for relief being sought were that the state knowingly elicited false testimony from Andrea Reed, which left a false impression that Skinner confessed to Twila's murder. And this is because Andrea Reed was apparently feeling guilty about her role in sending Skinner to death row. And so now she was claiming that she was threatened and she was coerced and she was intimidated by police and the DA, and that everything she testified to was a lie, that Skinner couldn't walk, he couldn't talk, he could barely say her name when he got to her trailer. She had no idea how he got to the trailer, which was like 4 blocks away from his house. But she had to bring him into the trailer. She had to do everything for him. He couldn't do anything on his own. And he was just so stuporous when he got to her trailer that he couldn't have possibly murdered Twila and the boys.
What do you think is behind these changes? I mean, why do people make these Like, why do they make such crazy retractions?
Well, Skinner's manipulative, so I could imagine him reaching out to her through directly or through third parties. These investigators are incredibly manipulative. You know, I had an acquaintance on one of the discussion boards in the old days of the internet bulletin boards whose daughter was murdered. Her killer was on death row awaiting execution, and investigators actually came to her and tried to convince her that she had been lied to by the DA and that the facts were as the convicted killer claimed, and that the real person who killed her daughter cut a deal and got life imprisonment because his father was wealthy and influential.
Kind of
And
like
she
I'm having a
basically,
senior moment. Who was the guy in the West Memphis 3 case? The Ron. Oh, I'm having a senior moment. But but I know what you're saying though. These guys that just kind of twist and turn and get all these witnesses
Ron
confused.
Lax.
Yeah, Ron
Lax.
Lax. That's
Yeah.
right.
Yeah. And I mean, I've had other family members say that these investigators really were. They came and they tried to con him. And we know in the West Memphis 3 case, Pam Hicks and Mark Byers were conned by being told the DNA evidence was absolutely exculpatory and conclusive, and it proved Terry Hobbs killed the boys.
Right.
When that was the furthest thing from the truth.
Well, and I don't mean any disrespect, but I'm guessing if any neighbors of Skinner, it's probably not the president of the Gray County Mensa Society, just to be honest. I mean, I hate to say that, but I could see how they might be more easily manipulated than your average bear.
No, she was not. And, and I think sometimes they're manipulative in that, like we see it with the Reed Smith investigation with Richard Glossop.
Yeah.
They ask leading questions and they let the witnesses know where their statements need to go. And I mean, in Swearingen, there was a former medical examiner who, when she was called to a federal hearing to testify in support of Swearingen, she said, I made changes to that affidavit. It should never have been filed. But unfortunately, she couldn't produce the changes she had made. But she kind of recanted the affidavit she provided to Swearingen's attorneys because it didn't agree with what her testimony would be. So, but yeah, Andrea Reed I think she felt guilty. He was a former boyfriend. She was a sponsor for him in AA.
Yeah.
She was trying to help him get clean. And so she felt bad for her role because she was described as a state star witness, although the state star witness was really, the DNA that, conclusively linked Skinner to these murders. He also alleged that he was denied due process because a police officer and district attorney's investigator threatened and intimidated Reed, causing her to give false testimony about Skinner's condition on the night of the crime, that he was denied due process because the prosecutor did not disclose that Reed was threatened by his investigator and police officer. He claimed ineffective assistance of trial counsel in violation of the Sixth Amendment by failing to effectively cross-examine the state star witness Andrea Reed, failing to offer an effective closing argument, which could have discredited part of the state's bloodstain evidence, failing to prove that Skinner was allergic to codeine, failing to obtain and offer evidence that another individual attempted to rape Twila, and failing to have experts perform scientific tests, which would have exonerated Skinner. And this is where the myth that DNA evidence was going to exonerate Skinner was born. Skinner's Sixth Amendment right to effective assistance of counsel was violated because Harold Comer had a conflict of interest. Again, he was the former district attorney, and he was the district attorney who convicted Skinner of aggravated assault of a police officer and unauthorized use of a motor vehicle. So that means that he could not have ethically challenged those convictions during the punishment phase, although his co-counsel could have done that without any problem. But he just couldn't do it. Skinner also claimed that his right to effective assistance of counsel was violated at the new trial stage because Comer apparently wanted to withdraw and the judge would not allow it. And Skinner may have wanted Comer to withdraw at that point, and the judge would not allow it. And that was done without addressing whether Comer did have a conflict of interest. He also alleged that his 6th and 14th Amendment rights were violated because the trial court ordered him to disclose an expert's work product to the state without requiring the state to provide reciprocal discovery of such evidence. He claimed the sheriff violated his right to counsel under the federal and Texas constitutions by reading and copying privileged correspondence between Skinner and his attorneys regarding trial strategy and facts of the case. And finally, that the trial court violated his 6th Amendment right to consult with counsel by ordering the bailiff to separate him from his attorney during every recess at trial. So that's the first round of federal post-conviction claims. On April 12th, 1999, the motions were referred to a magistrate. The state filed a motion to dismiss, seeking dismissal without prejudice for failure to exhaust state remedies. Because remember, he didn't pursue these claims in state court. So the state court had not yet been given an opportunity to rectify these errors. And the state had recently, the legislature had recently changed the post-conviction law to permit people who had filed untimely writs to refile and pursue state post-conviction relief. Skinner filed a cross motion to just abate the federal proceedings while he returned to state court. There was a telephone hearing held on April 19, 2000. The magistrate issued a report and recommendation on July 13, 2000, finding that the newly created state law was an amendment to Article 11.071, which would allow Skinner to pursue a state habeas claim, to file a new application in a state habeas claim. The state had argued that abeyance was not necessary to preserve Skinner's rights, but the magistrate found that he didn't agree with that standing, and he recommended granting the abeyance rather than dismissal in this instance, concluding that since the death penalty had been assessed, even the remote possibility that petitioner's habeas application may not be heard upon his return to federal court justified that abeyance. And this was basically based on limitations under AEDPA. If they dismissed this habeas writ, down the road, when the case he refiles, it could be perceived as untimely or argued to be untimely. And usually timeliness is not something that either party can waive. Timeliness is set in stone, and if it's untimely, it's gone.
Is that just because time is just objective? Like,
correct.
There's no
correct.
Yeah.
Statutes of
It
limitations.
is what it is.
Yeah. Statutes of limitations and prescription, as we call it in Louisiana, are pretty much set in stone. And they're pretty inflexible. Many, many years ago, one of the attorneys I worked with had a medical malpractice case that was filed in state court after the medical review panel process concluded. And during the filing of the petition, someone put the wrong year.
Ugh.
And so we had to defend against an exception of prescription, basically by getting an affidavit from the doctor attesting, or getting certified copies of the records rather, and filing them showing that the treatment occurred in the year after the date in the petition. But God bless that person. It wasn't me, but God bless the person, because they did have the wrong date throughout the entire petition. They had the treatment 1 year before the actual treatment date. And eventually we were vindicated because the judge dismissed the exception of prescription, and kind of chided the defense attorney for saying, for refusing to accept that the medical records showed the date in the petition was wrong. So, and the firm didn't appeal that. So, anyway, going back to this, the magistrate judge recommended that the petitioner be allowed to return to state court for purpose of complying with the Texas statute in question, and that he should proceed with filing the initial pleading in state court on or before 30 days from the date of any order adopting this recommendation. On the 31st of July 2000, the judge issued an order. Basically, Skinner had requested the magistrate judge issued an order that clarified the language of the report to require only that petitioner file a motion for appointment of counsel within 30 days of the adoption of the report. The magistrate used initial pleading, and I guess Skinner wanted to make sure that that did not mean an actual writ. It meant an initiating pleading to appoint counsel or to set a schedule or whatever. So the request for clarification was granted, and the magistrate clarified what he meant. The order was filed by the judge on August 1st, 2000, and basically adopted the magistrate's report and recommendation. Repeated the clarification about the initial pleading language, and granted the cross motion to abate and denied the motion to dismiss. A motion to establish new filing deadline was filed on August 30th, 2000 at the Texas Court of Criminal Appeals. An order was entered granting the motion on August 31st, 2000, and setting a date for the application in 180 days from that order on August 31st. The writ was filed on April 9th, 2001, as writ number 2003-04. However, on October 10th, 2001, the writ was dismissed due to pending federal habeas corpus petition. And that's basically the doctrine of a habeas corpus abstention, which means you can't pursue state remedies while you're pursuing federal remedies. And that's why the Attorney General wanted it dismissed.
Right. That makes sense.
But again, there was kind of it was a conundrum, because if they dismissed it, then the original filing date would cease to exist. Now, I don't know whether, if you haven't completed state post-conviction, then no, EDPA is the date your conviction becomes final. So maybe that's why. And those types of things are also kind of like, they're not in plain English, and you have to kind of use the black arts to interpret them.
Yeah. That's what it seems like. I mean, a lot of these
A
things
crystal
are
ball.
so, yeah, it is a whole other language.
So, so the case went back to federal court. The state filed a motion to dismiss on December 10th, 2001 for failure to exhaust state remedies. But I think what they were doing was they were trying to get him back into state court to pursue in state court. And they filed a motion on the 11th of December to reopen the abated proceedings. Skinner filed a response to the motion to dismiss on the 25th of January 2002. There were a lot of things going back and forth in the record between January and September when the magistrate ultimately decided the issue. So again, we're looking at where there's probably going to be an allegation of a rush or a rubber stamping by the courts in Skinner's case. We can see the magistrate took 8 months, a little bit less than 8 months, to decide on the motion to dismiss. And when he decided, he ultimately decided to protect Skinner's interests, or in a way that protected Skinner's interests rather than proceeding as the state suggested should be done. And I'm going to read the whole decision or the whole summary. Basically, the magistrate held that even dismissal without prejudice did not preserve the original filing date for statute of limitations purposes, that it was not clear that all of petitioner's federal claims were unexhausted, and it appeared that one or more of his claims were presented to the state court on direct appeal. And if there was a risk that petitioner could be time barred from refiling in federal court, it should be his decision whether he should return to state court or, I'm sorry, I didn't have that page, state court, and run the risk of losing any chance for federal habeas relief. And so the magistrate judge recommended that the motion to dismiss be denied, which was adopted by the judge on September 27th. The objections filed by the state were overruled, and the motion to dismiss was denied. This also set up Skinner for the opportunity to conduct discovery on his claims, as well as to have an evidentiary hearing, because the record of his claims was not developed in state court. So on December 5th, 2003, Skinner filed a motion for discovery, which was granted on April 18th, 2004. And he was granted leave to conduct limited discovery on the sheriff's handling of his mail. So he was allowed to depose the sheriff at the time regarding the handling of his mail. He was allowed to seek production of records related to Andrew Reed's involvement in the case, to receive all documents possessed by Stubblefield, the Gray County Sheriff's Office, or the Gray County DA related to whether Skinner's mail was read by Stubblefield and or copied and provided to the DA. He was allowed to obtain chain of custody and, with suitable arrangements, the plastic bag and exemplars of Bobby Donnell's fingerprints from the state. He was also allowed to obtain all bench notes from Gene Screen related to DNA testing done in 2000, which was conducted by DA Mann at the urging of David Protest, who came into this case in 2000, just prior to being found out for framing Al Story Simon in Chicago and releasing murderer Anthony Porter. But that's another case.
Oh my God. Yeah, that case is really disturbing. That's unbelievable.
And protests had a downfall eventually and
Yeah.
ceased to be involved with this case. And I'll talk about the gene screen.
He needs to be in prison.
Yeah. I'll talk about the gene screen findings next week. I felt like I didn't want to go into the rabbit hole aside from the trial record findings, because at this point, even the gene screen results are not part of the record, a really official part of the record. They're just they just exist factually outside the record. On the 22nd of June, the parties entered an agreed order extending time to conclude that discovery to August 6, 2004, because the original order wanted it concluded by July 18, 2004. There was a motion to conduct further discovery filed in October of 2004 on the 6th. Skinner wanted to depose a deputy who was identified in a memo that was produced by the Gray County Sheriff's Office. However, that motion should have been filed before discovery was supposed to have concluded rather than after, which was on July 25th, 2005. The order to conduct further discovery was denied because all discovery is closed, and Skinner did not show good cause sufficient to warrant the discovery sought. On the 25th, an evidentiary hearing was set for October 4th, 2005. On the 6th of September, 2005, that evidentiary hearing was rescheduled for November 16th, 2005. On the 9th of November, 2005, an order was entered overruling objection to the order denying further discovery and dismissing Skinner's appeal on that order without prejudice to renewal after the evidentiary hearing. I think he also filed an objection to the motion for limited discovery, or the order on the motion for limited discovery, granting limited discovery rather, and that was included in this order. Basically, both of the objections were overruled and he could refile after the evidentiary hearing concluded. The evidentiary hearing was held between on the 16th, 17th, and 18th of November. And facts supporting the 1st through 5th and 8th claims were admitted at the hearing. Post-hearing briefs were filed on March 6, 2006. Replies to those post-hearing briefs were filed on March 14th. And then the report and recommendation of the magistrate judge was entered on September 29th, 2006, denying habeas corpus relief. Skinner objected to that recommendation on the 17th of November, 2006. On the 22nd of February, 2007, the judge issued an order adopting the report and recommendations from the magistrate judge and denying habeas corpus relief. That report and recommendation is 79 pages long, and basically he just found that none of Skinner's claims based on the facts in the record, the findings of the Court of Criminal Appeals, and the testimony at the evidentiary hearing, he found none of Skinner's issues had any merit. Andrea Reed's recantation of her trial testimony was not credible. Claims that Skinner was allergic to codeine were not supported by a medical report diagnosing him with this allergy. And there's also, he was treated at a hospital that night or early that day of January 1st, and he was not documented to have been suffering any symptoms associated with an allergy or an allergic reaction.
Yeah. Well, I mean, these things are always tough, right? Because at the end of the day, right, you want justice to be served, but it's really hard. Like the appeals process can't be just to re-adjudicate every case. It can't be like, oh, I've come up with 5 new things that oh, my witnesses are recanted. Oh, I'm allergic. All that stuff you had plenty of opportunity to present at trial.
Correct. And also, a lot of in support of the claim that he was allergic to codeine and that his attorney should have established that at trial, they used medical records where he said, I'm allergic to codeine. But drug addicts will say they're allergic to codeine to get narcotics.
Right.
I do have a legitimate allergy to codeine because the 2 times I've been prescribed Tylenol with codeine, which I had no problem with, I developed a rash on the underside of my arms from my wrist to my underarm. And the rash stayed until the codeine had worked its way out of my system.
Mm.
And it was very uncomfortable. So yes, I tell people I'm allergic to codeine, but so far all I've ever gotten is a rash on my arm. I've never had any stronger allergic reaction. But I could get codeine and have a stronger allergic. But stupor is also not one of the general
one of the symptoms
things of an allergic reaction. You either have a rash, you develop hives, you start having swelling in your airway, you start having swelling in your tongue, in your lips, in your mucous membranes. You don't have a stupor. And that's another thing is Skinner had blood on the front and back of his clothing. But he claimed his news story was Bob Donnell came in the house and killed Twila and the boys. And he was lying unconscious on the couch when all this happened. But if you're lying unconscious on the couch, how do you get their blood on the back of your clothes? And we'll go into the jacket more next week, because that's one of the conspiracy theories that Skinner is touting related to the DNA testing. So we'll get into that one later. All right. So
well, that's a lot like the Darlie Routier case where, she claimed she was just, a light sleeper and was asleep on the couch. Somebody came in, murdered her kids, and then she was suddenly awakened by one of the kids.
Correct. All right. So on March 7th, 2007, Skinner filed a motion to alter or amend the order denial of relief pursuant to Rule 59E. That was denied on April 10th, 2007. A motion for a certificate of appealability was filed on May 9th, 2007 by Skinner. He also filed his notice of appeal on both the denial of habeas relief and the denial of the motion to alter or amend, which I have wrong in your notes. My apologies. The state filed a response to the motion for certificate of appealability on May 22nd, 2007. And, and that's another interesting thing that I want to point out on this, because this case really documents it pretty well. In the times where there's a quick turnaround on something, it's imposed on the state to respond to something rather than Skinner to initiate something. The report and recommendation denying the certificate of appealability was entered on June 14th, 2007. Skinner, of course, filed an objection on the 29th of June. And an order was issued on July 2nd. Pardon me. Basically overruling Skinner's objection and adopting the report and recommendation denying certificate of appealability on all issues being sought by Skinner. And that was mostly the ineffective assistance claims related to cross-examination of Andrea Reed, establishing the allergy to codeine, using a blood spatter report more effectively at trial, and a couple of other claims, again, related to the ineffective assistance of counsel claims. I think the conflict of interest claim was one of them. And the Fifth Circuit Court of Appeal issued its ruling or opinion on May 14th, 2008, finding that counsel was not ineffective for failing to conduct DNA tests of crime scene evidence not tested by the state, and his failure to impeach a witness with a prior written statement during cross-examination or present evidence that the inmate believed he was allergic to codeine was not prejudicial. The inmate's claim that trial counsel should have made use of a blood spatter report prepared by a police officer had merit. Counsel offered no strategic reason for failing to utilize the report. The inmate argued that the blood spatter report proved that one victim was in the same room as the second victim while the second victim was being assaulted, and that the murderer therefore would have had to have fended off two live victims at the same time. If true, that would have bolstered the primary defense theory that the inmate was too incapacitated to commit the murders, and it would have undermined part of the prosecution's theory. The inmate's argument that counsel was ineffective for failing to discover and present a certain witness's testimony had merit. That testimony offered strong circumstantial evidence to corroborate the defense theory that another person was the murderer. And that's actually, this was an order granting the certificate of appealability. It was not the opinion ultimately on the writ of habeas corpus denial. Sorry.
No worries. Gotcha. That makes sense. That actually makes more sense.
I started reading it. I'm like, wait a second. That's not what they found. No, wait. But that's the arguments that they made, and they found that those arguments were worthy of further development in the appeal.
Yeah, I think that makes more sense.
Yeah. So the application for COA was granted with regard to the claim of counsel's failure to make use of the blood spatter report, and with regard to the claim of failure to discover and present a witness's testimony. The application for a COA was denied with regard to all other claims. So he was allowed to develop the blood spatter report, ineffective assistance claims for failure to use the blood spatter report, and presenting a witness about that was discovered during post-conviction, claiming that she saw Bob Donnell cleaning out his truck inside and out, and the day after the murders, and that he had no reaction to being told Twila was dead. Or Twila and her sons were dead.
I mean, my truck's pretty messy, but if every time I cleaned it out, I got, became a murder suspect.
Yeah.
I'd be in trouble.
Yeah. So the Fifth Circuit's opinion was actually rendered on July 14th, 2009, after briefing and filing of the habeas record and the hearing transcripts, etc. The court found that the inmate failed to demonstrate that the omission of the report, the blood spatter report, was sufficiently prejudicial. Even taking the report at face value, it did not establish beyond mere speculation that the blood on the son was the girlfriend's. And further, the evidence showed that the girlfriend would have been unconscious from strangulation, and therefore the inmate would not have had two active victims in the same room. Further, there was ample evidence that the inmate was the murderer, including his confession and the lack of physical evidence of any other perpetrator. The court held that there was no reasonable probability that, but for counsel's failure to use the blood spatter report, the result of the proceeding would have been acquittal. And the district court's judgment was affirmed. They also found that the testimony regarding Bob Donnell cleaning out the truck and having no reaction to being told Twila and her sons were dead, that was just speculative, and that wasn't actually clear and convincing evidence that would exonerate Skinner. Skinner filed a writ to the U.S. Supreme Court on November 23rd, 2009. That writ was discussed at conference on February 26th, 2010, and an order denying the writ was entered on March 1st, 2010. Now, we're going to kind of switch gears a little bit. Skinner, calling himself a paralegal, has also filed, probably pro se, multiple other claims in various federal courts.
He's just basically putting as much paper out there in the hopes that something will stick.
Correct. He has filed a motion for preliminary injunction in the Southern District of Texas because that is the jurisdiction where the prison where he's incarcerated is. That was called Skinner versus Staples. I don't know what the preliminary injunction is, although it may have been related to an early execution order. That was denied by the trial court or the district court, and on April 14th, 2000, the Fifth Circuit affirmed that denial. Then he filed a writ to the U.S. Supreme Court, which was denied on October 7th, 2002. He filed a claim in the Eastern District of Texas related to his treatment for hepatitis C in the prison. That
seems germane to the murder.
Yeah. And I don't know why it was filed in the Eastern District of Texas, unless maybe that's where the corporation that runs the medical clinic is located. That was apparently dismissed, or he was seeking appointment of counsel. And the Fifth Circuit on November 12th, 2003, denied his request for appointment of counsel, but vacated and remanded for further factual development his claims that defendants were merely monitoring his chronic condition rather than providing medical care consistent with currently accepted standards. So he got to continue pursuing that claim. Don't know whatever happened, because that's the last time I hear anything about it. He also had pursued state DNA proceedings beginning around 2001. Again, we had DNA showing the blood on Skinner's clothing was a mixture of his, Twila and Elwin's. Some stains were a mixture of Twila and Elwin, some were his, some were all three. He was in very bloody clothing when he was arrested. Then in 2000, at the urging of David Protests, John Mann sent some evidence to a company called Gene Screen to be examined. Gene Screen included Twila as a contributor to blood on the cover of a blue notebook found in the living room, a hair found on her back, a hair found on her left hand, and a hair from the axe handle. I think they did a mixture of mitochondrial DNA as well as nuclear DNA testing. Appellant was included as a contributor to DNA found on a cigarette butt. Twila and Appellant were both included as contributors to a mixed profile from hair on Twila's right hand. There was also a piece of blood-stained gauze, which reflected the profile of an unknown male individual, and a cassette tape with blood on it reflected a profile that was a mixture of two unknown individuals. There were those results were basically inconclusive, and the unknown male may have been an investigator. It may have been a male unrelated to the crime, for whom they had no DNA profile with which to compare. And I don't know whether they had Elwin and Randy's. I'm going to go through the Gene Screen reports in a little bit more depth next week, next episode. So when I'm preparing next week, I'll go into those a little bit more.
Gotcha.
See if they even had reference from.
Yeah.
If they didn't have reference to Elwin and Randy, then they had nothing to compare things to. And they don't have.
They probably didn't.
And they don't have a reference sample from Bobby Donnell.
Right, exactly.
To ever compare anything to. So
Yeah, I guess just throwing stuff against the wall to see if it sticks.
yeah. On October 9th, 2001, Skinner filed a request for DNA testing in the 31st District Court. The court denied that request on July 2nd, 2002. Skinner appealed to the Texas Court of Criminal Appeals, which ordered the trial court on December 18th, 2002 to issue findings of fact to issue an order with an Article 64.03 determination and ordering a supplemental record be filed within 30 days of that order. The supplemental record was filed on January 22nd, 2003, and the court ruled on the motion or the appeal, issued its opinion on September 10th, 2003, ultimately affirming the denial of DNA testing. However, Skinner filed a motion for rehearing on September 25th, and the rehearing was denied on December 10th. I've got 2007, but that should be 2003. And they withdrew the September opinion and issued a new opinion. And they basically found that Skinner did not meet the standard of proof under Article 64 because the evidence from the previous tests that had been done were inculpatory. The analysis demonstrated the intermingling of the victims and defendants' DNA, probably during the time when Twila was struggling for her life. Because defendant's DNA was found mixed with the victim's DNA in her right hand during the autopsy, there was nothing about the other items found at the crime scene that, if linked to a third person, would cast doubt on defendant's presence at the scene or his involvement in the offense. Given that evidence, the presence of third parties' DNA at the crime scene would not constitute affirmative evidence of innocence. And so they affirmed the judgment. And that was one of the conditions of Article 64 at that time, was that you had to have exculpatory results that would have led to you not being convicted or tried. And with the inculpatory results from the prior DNA testing, that would not, no exculpatory DNA from this additional testing would refute those inculpatory results.
It's going to take me a minute to wrap my head around that. I'm trying to process. I'm like, wait a minute, what?
Basically, what it means is that DNA testing and DNA results and DNA evidence is not quantity over quality. You don't have to have 100 pieces of DNA evidence that all link one person, although that certainly is helpful. But in a case like Rodney Reed, where you have linked to DNA from internally and externally, unknown male DNA on the belt is not going to exonerate Rodney Reed. Even Jimmy Fennell's DNA on the belt is not going to exonerate Rodney Reed, given that the time that's passed since that evidence was collected and the fact that it was handled ungloved at trial and was stored in a box with other evidence that was touched by other people, and you're looking for touch DNA, that's not going to exonerate you. Yeah. I mean, you could have one piece of DNA, but in this case, there's more than one piece, because there's the initial DNA from the blood on his clothing, and then there's the DNA from evidence collected at autopsy that links him to Twila's murder, because it's a mixed profile. She was bleeding and he was bleeding. Now the thing that they've done similar to Rodney Reed. They try to challenge the weight of that DNA evidence and saying, well, that doesn't really prove he's guilty. You know, in Rodney Reed, they say that that's because they had this, that's evidence that was there because they had this secret affair and they saw each other the night before she was murdered, or a week before she was murdered, or 2 weeks before, or a month before she was murdered. And so his DNA was just hanging around. So that's how that works. It's not quantity. You don't have to have 100 pieces of evidence. You can have a single piece of evidence with your perpetrator and your victim's DNA, and that can be enough to link your perpetrator to the murder irrefutably. Does that clear it up?
I think so. I'm processing, but yeah, I think that makes sense. You did a good job explaining it. Yeah, I think that makes sense, I think.
Okay. Next week, when we talk about the 2022 opinion, I think it hopefully will be a lot more clear for you.
Yeah, I think so. Yeah, I'm sure.
So
No, you did a good job explaining it. I'm just having to think to make sure I have everything in order.
Thank you. All right. So he filed the second motion for DNA testing on July 30th, 2007. That was denied for failure to seek DNA testing at trial because, again, the law had been changed, and one of the conditions became if the DNA evidence could have been done at trial and you didn't ask for DNA at trial, then you can't ask for DNA evidence now. And I think Skinner had challenged the failure to seek DNA evidence, and his attorney basically said, I was afraid to ask for DNA evidence because I didn't want to find any more of his DNA or any more of their DNA to link him even, more irrefutably to these murders. And that was found to be a reasonable strategy by the attorney. So now by this time, he's being represented by an attorney named Robert C. Owen, who is at Skadden Arps, who is the firm that's representing Rodney Reed as well. After the motion was denied, he appealed to the Court of Criminal Appeals. That appeal was filed on January 4th, 2008. On September 23rd, 2009, the Court of Criminal Appeals ruled and basically held that the fact that the testing would be outcome determinative if conducted did not mean the testing was in some sense unavailable. No showing of ineffective assistance counsel was made because the failure to seek DNA testing was a matter of sound trial strategy. Trial counsel explained he did not ask for testing because he was afraid the DNA would turn out to be defendant's. A number of facts indicated that defendant had the capacity to commit the murders. A substantial amount of incriminating physical evidence connected him to the crime. Thus, his proffered evidence on the issue of incapacity did not call into question defense counsel's strategy to forego DNA testing. And so the court affirmed the trial court's judgment. After this denial, Skinner waited a while, and then probably because he had another execution date, which we will talk about in more detail next time, he filed a federal civil rights claim in U.S. District Court seeking an order from the federal district court finding that the district attorney was violating his constitutional rights for not giving him evidence to get DNA testing. The petition was very carefully crafted to leave out any challenge to the handling of Chapter 64 by the Texas courts. So basically he was saying, even though I don't meet the state law, the district attorney is obligated to give me access to this evidence to test it because it could exonerate me.
That's an obnoxious statement.
Okay. Yes, it's highly obnoxious, especially given this isn't a case where there was no DNA evidence. And they're asking for DNA the first time. Now, again, the illogical claim is, well, test everything. We should always test everything. Now we would test everything. Well, in 1995, you couldn't test everything.
Exactly. Yeah, we
even
have that
in
bad habit of
2001, you couldn't test everything.
Well, yeah, we have this bad habit of trying to litigate the present with, or litigate the past based on standards of the present. It's like, times have changed. Technology has changed. Lots of stuff has changed.
Yeah. And so in this particular, he was still being represented by an attorney by the name of Douglas Robinson. And I think I neglected, Douglas Robinson was representing him in the federal habeas at one point as well. And I neglected to put him on there. It just gets confusing with the way his case went back and forth between state and federal. He was also still being represented by Robert Owen and an attorney by the name of Maria Cruz Melendez. Switzer was represented by 3 attorneys, primarily Mark D. White. The case was in the Northern District of Texas. Honorable Mary Lou Robinson, judge. Honorable Clinton E. Averett, magistrate judge. So these were the same judge and magistrate judge that presided over the federal habeas claims when they went back, I believe, or it may have been from the beginning. The petition was filed November 27th, 2009. A motion to dismiss was filed December 29th, 2009 by Switzer, and basically similar to Rodney Reed, challenging Skinner's claim based on a few cases that kind of said the federal court can't tell the DA what to do when it comes to state law DNA claims, essentially. But the report and recommendation was issued on January 15, 2010, which found that the cause of action under Title 42 U.S.C. 1983, asserting that defendants' refusal to allow him access to biological evidence for purposes of forensic DNA testing violates the 14th Amendment right to due process and 8th Amendment right to be free from cruel and unusual punishment, could proceed. I'm sorry. It could not proceed, and recommended granting the motion to dismiss and dismissing plaintiff's complaint. That order was entered on January 20th, 2010. Skinner did have an execution date, so things moved quickly. The Fifth Circuit issued a judgment on January 28th, 2010, and basically affirmed the district court's dismissal of Skinner's civil rights claim. A request for injunction was filed by Skinner in the trial court, in the district court, which was denied on the 8th of February. He filed an application for stay of execution with the U.S. Supreme Court and a writ to the U.S. Supreme Court on February 12th, 2010. The question presented was, for 10 years, Henry W. Skinner sought access to DNA testing that could prove him innocent of the murders that landed him on death row. After the Texas courts arbitrarily turned back his diligent attempt to take advantage of state statutes affording such relief, he sued in federal court under 42 U.S.C. 1983 to vindicate his due process right to fundamental fairness in the operation of Texas's scheme. District Attorney's Office versus Osborne basically is the first federal DNA or U.S. Supreme Court DNA case. This is probably number 2. District Court dismissed Mr. Skinner's 1983 suit solely on the ground that his claim sounded only in habeas corpus, and the Fifth Circuit summarily affirmed. The question presented is the same one the court granted certiorari in Osborne to decide, but left unresolved. May a convicted prisoner seeking access to biological evidence for DNA testing assert the claim in a civil rights action under 1983, or is such a claim cognizable only in a petition for writ of habeas corpus? That was obviously written by his counsel.
Yeah, clearly.
Not, but the
Like,
rest
can we
of it
rewrite
is,
that in English?
Yeah. So the stay of execution was granted on March 24th, 2010. The petition was discussed at conference on May 20th, 2010, and permission to proceed in form of papyrus, which means without paying costs, and petition for writ was granted on May 24th, 2010. Skinner filed a motion to appoint counsel on June 4th. That was discussed at conference on September 27th, 2010, and a briefing schedule was issued on June 23rd, 2010. I've got those out of order, sorry. And oral argument was set on July 20th, 2010 for October 13th, 2010. The motion to appoint counsel was granted on the 28th of September. Oral argument was held on the 13th of October. And on March 7th, 2011, the court reversed the Fifth Circuit and remanded the case back for further proceedings, basically holding that while test results might have proven exculpatory, that outcome was hardly inevitable, meaning that he could proceed under 1983. And that the other things, the other bars asserted by the respondent were not applicable. Rooker-Feldman doctrine being one of them, and that he did properly invoke Section 1983. So basically, they didn't find that he had a right to DNA testing. All they found was he had a right to challenge the denial of DNA testing as a civil rights claim in federal court. And it's often misrepresented as being a right to DNA testing. But the U.S. Supreme Court has never found that there is any due process right to DNA testing. So, and that was a 6-3 decision with one dissent from Justice Thomas. And so that is part 1, Henry Watkins Hank Skinner. And we're done for tonight. Any questions, comments, Kyle?
Oh, sorry, I didn't realize I was on mute. It still
Yes.
amazes me, these cases that drag out for, what are we going on 30 years? I mean, it's crazy.
Yes. New Year's Eve will be 30 years.
I mean, you want justice to be done, but it feels like justice should be done faster than 30 years, either whether it's an exoneration or an execution.
Yeah. And the DNA, this case, Skinner versus Switzer ended in 2011. 11 years later,
Yes, yeah, exactly.
we finally have an opinion from the Court of Criminal Appeals regarding the results of DNA testing and the court's handling of those results. And I can promise you, Skinner is going to try to go back to federal court.
Well, and it's interesting because I think you've, intentionally or unintentionally kind of revealed some of the strategy is you file all this stuff. They know that with the DNA, it's just going to get sucked into the courts for 10 years. And I mean, regardless of the outcome, you bought yourself 10 more years.
Yeah. And the shotgun approach.
Exactly.
You fire it all off and see what sticks, see what hits.
Right, exactly.
See what works. And his claims have evolved over the years. At trial, he never mentioned the allergy to,
that's exactly
the allergy to codeine was not mentioned. It was just that he ingested it and he was in a stupor because the level was so high. And then because that didn't work with the jury, his expert said, well, the level was so high. And if he was allergic, that would amplify the effect. So that's why he was in a stupor. But
well, and I always go back to, I get it. Details can change. But if you're truly innocent of a crime, and especially if somebody is targeting, like looking at you as a suspect, your story doesn't change and you tell them everything that could possibly exonerate you. Things don't magically come to your mind 20 years later.
Yeah. And another problem with the DNA claims and the seeking the DNA testing, they come up with all these things like the level of codeine and stupor from that didn't work because one of the problems is that his expert could not say when he took the codeine. So his expert had to admit that he could have taken the codeine after the murders. And that would account for the high level in his blood at the time of his, blood draw at the hospital.
Well, and if he was in a codeine stupor, how did he get magically waked up when one of the victims, pushed on his arm, just like Darlie Routier?
Yeah, yeah. And
like Darlie was like, oh, I'm a light sleeper, but I totally slept through the murder of my kids, but then somebody nudged me and I woke up.
Yeah. And I've always said in Darlie's case and Skinner's case, if someone came into the house to commit these murders, Skinner should have been the first person that got taken out.
That's exactly right. That's the thing that people like those that are in it, the innocent fraudsters are like, that's a fantastic point. You're always going to attack the most dangerous threat first, which in this case is the largest adult.
Mm-hmm. Well, Elwin and Randy were actually both bigger than Skinner, but Elwin had muscular dystrophy and diabetes.
Right. Well, that's what. Yeah, exactly.
Was not they were both physically
mentally
robust.
physically ill. Exactly.
I don't know about Randy, but all evidence indicates Randy never woke up. Skinner is a lot like Bobby Donnell. Skinner is a little man with a Napoleon complex who thinks he's the biggest, baddest dog in the junkyard. He's also a liar. He admitted to taking Xanax and then codeine's found in his system. Now he claims he's colorblind and he accidentally picked up Twila's cup where she had dropped codeine, because that's apparently a cocktail. You have vodka and you drop pills in the vodka. And that makes you even higher.
That sounds good for everybody.
That's like a drug addict. That's a drug addict thing. That is a freaking.
I don't mean to make light of it, but it's like, oh yeah, vodka's not good enough. Codeine's not good enough. We need to
put them together.
Drop it in there.
Like I said, he claimed he took Xanax. And then so when it looks bad, the voluntary intoxication looks bad. Then he accidentally ingested the codeine because he mistook Twila's cup for his own. And that's why he was in the stupor. But he wasn't in a stupor at midnight because he got out of the house and went 4 blocks to Andrea Reed's, went into her trailer and did all these things in her trailer. And that was another, like I said, that was another problem with his expert
Yeah.
who, you know, couldn't explain how, if he was in such a stupor, how he did all these things. And there are statements from Skinner that when he was drunk, he could do all kinds of things. He just didn't remember them
Right.
because he'd
That's
black
probably what
out.
happened. That's probably what happened.
Yeah. I think he woke up, his big bottle of vodka was gone. He got pissed. Twila came home. He was awake. He was pissed. He'd waiting on her. And so he went off on her and they fought, and maybe she tried to defend herself with the axe handle and he took it away, strangled her, picked it up and beat her to death with it. I've always kind of wondered, maybe Randy and Elwin, maybe he attacked them before Twila even came home because he was so pissed.
Right. Yeah.
And he
Could
did
be.
have an MO of threatening women and their children.
Yeah, this sounds very consistent. Yeah, it's not exactly like he was the Boy Scout leader with not a single problem in the world and suddenly just is falsely accused. I mean, not a because as all these cases have similar things. It's just like Rodney Reed.
Yeah.
The guy was, accused myriad times of rape and assault.
Yeah. So, all right. Well, that is, I think that this is a good stopping point for us tonight. And we will be back in 2 weeks with part 2. Any final thoughts, Kyle?
No, just a wonderful job as always. Appreciate all your detailed research. You put so much into this. I hope everybody appreciates it.
Thanks. And I am going to try to be better about probably posting these case notes for people to to be able to download and reference in their own discussions of these cases out there on social media and out in the world. I promise that's one of my New Year's resolutions.
That's actually a really good idea because I find sometimes that people will make, really good points that you hear on a podcast or they'll cite an article, and then you're having a discussion with somebody and you want to go cite, sort of primary evidence, and then you have a hard time going to find it.
Yeah.
So I think that'd be a great idea.
Well, how would you like that to be your, because I'm not artistic and I'm not particularly creative, and I'll link everybody to my Rodney Reed site just so you can see how not creative visually I am, not artistic.
All right, that sounds like a good project for next year.
Yeah. Maybe you can create a
Yeah.
website for the show.
Absolutely.
And that can
Let's
be
do it.
your job.
Yeah, there we go.
Update the website after the episode.
Got it.
We'll have to have a conference about that.
Yes, and that sounds good. That'd be great.
Okay, cool. We'll look at that for next year. All
Fantastic.
Right. And our season starts in January, so because I figure we'll go January to January or January to December per season.
Yeah, it makes perfect.
All right. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and guest co-host Kyle Evans. Sorry. If you like the show and want to know more, you can find us on Facebook or follow me on Twitter at O'Brien LN. Join us in 2 weeks for episode 20, State of Texas versus Henry Watkins Skinner, part 2, which will examine Skinner's multiple execution dates, including the recent September 23rd date set for him, and his multiple state court proceedings relating to requests for DNA testing. Until then, have a great 2 weeks and stay safe. Good night.